aware, it's a technology. Thanks, Ashrat. So, as most of you are aware, that SINE is a technology business incubator hosted at IIT Bombay. We provide start to scale support to startups, innovators, entrepreneurs. Uh, we provide this support at early stage of your innovation journey through different grant programs. We are partner with various government agencies such as GST, BIRAC, Ministry of Power, Ministry of Defense, for various programs. One such program I would like to mention here today is the BIRAC DIG program, because the call for this program is currently open. And it will remain open till 16th August 2023 till 5:30 p.m. Please make a note of it. It's not midnight, 5:30 p.m. 16th August. And this is a very early stage biotech funding, one of the largest early stage biotech funding up to 50 lakh for ideation to POC. And SINE is one of the implementation partner for this program. So if you have any queries regarding BIG program or application, or if you would like to apply through SINE as a BIG partner, do get in touch with us. We will also post our email address in the chat box for this particular, handling the queries. Do write to us. Now, moving on to our today's session. Here we are going to talk about a very interesting and important topic, that is how to address IP section in the grant proposal. Now, if I have to just emphasize that a strong IP portfolio can help attract investment, build brand value, protect innovation, enforce right, create licensing opportunities for startup, and it can also enable the international expansion going forward when you want to scale up your business. And safeguarding this IP is advisable and much easier in the beginning phases of your product development. And this is what we are going to talk today. And for this session, we have invited Mr. Durgesh from KNS Partner. Durgesh is a partner at one of the India's leading IP boutique firm, KNS Partner. He is one of the lead for life science practice at their Bangalore office and has been with the firm for over 15 years. Durgesh has a master's in biotechnology and a law degree, and is registered patent agent. Over the years, Durgesh has developed considerable expertise in advising clients on IP strategy and worldwide portfolio management. In sync with their business model. This involves deep conversation around the market of interest, visibility of IP, generated revenue, licensing issues, advice on critical IP issues, including contentious matters related to patentability, freedom to operate, due diligence, and technology landscape. With this brief introduction, I welcome you, Durgesh, for this session. And before I hand over the session to you, I have a brief announcement for the audience that we request all the participants to put their question in the Q&A chat box. We will address the queries towards the end of the session. You can also raise your hand and we can unmute you so that you can address your question to Durgesh directly. So Durgesh, thank you so much for joining us and agreeing to conduct this session at such a short notice. Thank you so much for that, and I hand over this session to you so that we can hear many things about IP. Over to you, Durgesh.
Thank you, Dr. Pranita and SINE and IIT Bombay for having me today, and thank you for all the attendees. It's a busy Thursday afternoon, and thank you for taking out the time. I will just begin by sharing my screen. And Pranita, if you can just let me know if you're able to see the slides. Pranita, are you able to see the screen?
Yes.
Okay, all right. Okay, so welcome everyone. Today we'll talk about intellectual property in general, different forms of IP, with a little bit of focused approach towards patents, and more importantly, also talk about what young entrepreneurs and startups and MSMEs should keep in mind from IP perspective, especially when they have to, go out there and approach these agencies for funding or grant proposals. Before we dive into today's topic, a very quick background about our firm. So we are K&S Partners. We were established in 1994. We have 6 offices across the country. As Dr. Pranita mentioned, I'm from the Bangalore office of the firm. We have put together about 350 plus in the firm. Most of us have technical backgrounds from either science or engineering domains. We have a law degree as well as patent agents. Our key practice areas within the firm are biotech, biosciences, pharma chemistry, materials, polymer, metallurgy, computer science, mechanical engineering. And then, of course, we also dabble with other forms of IP apart from patents, that is trademarks, copyrights, GIs, data, cyber, privacy law, and litigation. And we'll talk quickly about some of these other forms of IP during the presentation. We are also among the largest and most diverse pool of IP attorneys in the country and amongst the largest filers of international application originating from India. And therefore, it allows us to work with a lot of startups, a lot of MSMEs, and large-sized Indian as well as global organizations. In terms of our service lines, we work on advisory, which means in terms of searches, in terms of landscape studies, biodiversity law, and so on. We do prosecution, drafting, and filing of patent applications. We then also do transactional work when startups and young entrepreneurs and their companies get absorbed or merged with other companies. We help on IP assessments and evaluation on that front as well. And then, of course, if there are enforceability related issues, we then provide help on that front as well. We have a robust litigation team that takes care of all the court proceedings in terms of IP infringement and all those oppositions and revocations sort of things involving your IP. So with that background, let's dive into today's topic. And before we talk more about IP and why IP is required, I think it's also important to understand that in today's context, why is IP becoming an important aspect from the Indian perspective? Now, as we know, we as a country continue to grow. We have done well for ourselves in the last 2 decades. We are quickly becoming a very important consumer market for the world. Our GDP continues to grow. We have had an average of about 6% growth for last 2 decades. So as a country, we are headed in the right direction. And any country who is trying to do well for itself cannot ignore innovation. And innovation is all about carving a space in the competitive marketplace at the right time. You try and innovate with all your research, efforts, time, money. You innovate something, and then you also expect some kind of returns from that innovation. You also want to be ahead of the competition, and therefore you try and protect that innovation in some form or shape. When you protect, you become a market leader of sorts in that area or that technology domain. It then in turn brings commercial benefits for you, and you are also able to take action against anyone illegally trying to copy or use your innovation. So to sum it all, you are able to invest in your innovation and also get returns by protecting that innovation. In the past 5 to 10 years, especially in the last 5 years, there's been a lot of emphasis from the government sector as well, from the central government and state governments, to enhance the IP ecosystem in the country. There are various schemes that are being rolled out. There are lots and lots of incentives for startups and MSMEs that are now provided by central government, as well as different state government initiatives and funding schemes that allow for easy, filing and prosecution and grant of IP in India. There are perks and incentives being offered to different startups and young entrepreneurs, and therefore there is this atmosphere and environment of us as a country transitioning from just being a consumer of goods and services made outside of India to an innovation-led economy, not just consumer, but also someone who innovates. At the same time, even the judiciary is recognizing IP rights and patent law and different forms of IP very robustly. A lot of high courts now in India have specific IP divisions set up that take care of disputes on the IP front. So even the judges and courts are becoming better to handle IP disputes as and when they arise. And then, of course, because the judiciary is becoming stronger, it is providing better, protection to all the startups, MSMEs, and young entrepreneurs. So the overall ecosystem in India has strengthened quite a bit in the last few years. But that obviously is not the reason alone for young entrepreneurs or startups or MSMEs or even academicians to think about IP. What is more important is that when you innovate, when you invest a lot of time, money, effort, resources over a long period of time and come up with an innovative idea, it is also important that that idea does not fall into the wrong hands, or someone just doesn't simply take the liberty of copying that idea. So you also want to be able to protect your hard work, your innovation, and that in turn allows you to have an exclusive place for you in the broader, larger marketplace. By protecting your innovation, as I said earlier, you're able to obviously prevent competition and trespassers. And this is IP is no different from any other form of property. When you buy a house, you obviously try and build a fence around your house so that there are no illegal trespassers into your property. IP is exactly the same. You innovate, you build an IP wall around it so that your IP is not trespassed by anyone without your permission. And if they do so, you have all the right to sue them and take legal action and therefore enforce your rights. So that is a big inspiration. That's a big reason and motivation for you to look at IP, because all of your years of hard work, research, time, effort should not, be simply copied by a third party. Also, when you innovate and when you protect and when you do get an IP right, intellectual property right, in different forms, and we'll talk about different forms of IP, there is some sort of a validation that is already being created, because these IP rights are allowed by different government by government of different countries around the world. There is a sense of validation that, oh, if I have received an IP grant, there must be some kind of innovation in what I have done. So there is this sense of merit when you get an IP granted for your innovation. So it's sort of a kind of a validation mechanism also for your innovation. But the biggest reason why you should also look at IP is because of the commercial aspects, the returns that are associated with your IP. Now, this can be regardless of how small, young a company you are to an MNC or a global player. Uh, there are different sorts of, different categories of organizations, all of them who can take leverage or advantage of IP rights. So if you are a self-driven company, that means you have an R&D facility, you can manufacture yourself, and then you can also commercialize and take it to the market. Or be it a small, young company, a startup, maybe just a 2-3 people coming together and opening up a business. Any of these businesses can also gain from IP rights, because you, of course, will do the innovation, but you may not have the capacity and capabilities of taking it to the market. And that's where you will probably either license out your technology or work with other commercial partners to help you in the journey to take it from lab to the market. And of course, when we talk about smaller organizations, startups, MSMEs, there's always an opportunity for you to merge and be acquired by a larger player in the industry. And a strong IP portfolio has a direct impact on the value and assessment of your company. So again, from all perspectives, whether you want to sell the product or your innovation yourself, or whether you want to license it as an asset to another organization, a bigger, larger player in the industry, or you want to be acquired or merge with another entity, in all of those scenarios, IP acts as a very important asset for the organization. And of course, when that happens, the industry recognizes it. You obviously create a brand for yourself, and in turn, you attract investments. So to sum it up, it can be called as an IP-driven innovation cycle. So you innovate, you then try and get IP protection, IP rights over it. Of course, you have to pass certain criteria, then we'll talk about that. But once you pass those criteria, then if there is real merit in your innovation, you would be able to get IP protection. You then, become the exclusive player in that domain, in that market, in that country, in that geography, it obviously then therefore gives you that competitive edge over your other competitors in that space. You become the sole player. Because of that, you are able to scale up, you are able to commercialize, you are able to demand more value for your innovation. You obviously get remunerated, and the revenue generation is accordingly depending on how good or bad your innovation is. And then that in turn builds market confidence and attracts investments by investors, by funding agencies, and different grant schemes from the country. So it's important for you to look at IP as a tool, or as a way to build asset for your organization, no matter how big or small you may be, and whether you come from a business background or whether you come from an academic background. Now, Dr. Pranita talked about BIRAC big proposal, and that is one of the proposals that are currently ongoing. And there are so many other schemes and proposals, grant proposals that are out there that young entrepreneurs and startups can take advantage of. We have taken the BIG proposal as a template for today's presentation, and wanted to just see what kind of questions these proposals usually ask. And as I said, because the whole IP ecosystem in India is supporting and encouraging intellectual property generation, that is the reason why some of these proposals and grants and schemes are also very keen to ask the applicants on what their plan or journey has been in terms of IP creation. Have they created their own IP? Do they own their own IP? So for example, if we look at some of these questions, your first question in this BIG proposal template talks about company owning any IP related to the project. The second question talks about whether you have done your research and whether you are stepping on someone else's IP. Because tomorrow, let's say you get this funding and you want to commercialize this innovation in the market, but what if someone else owns an IP on it? You would be obviously trespassing their IP. So have you done your background work and research around that? And then the third question here is that if there are such close competitors or their IP, have you thought about cross licensing? Have you thought about how you would approach that issue? Have you thought about how you would negotiate with those third parties who may own IP in that space? So it's important for an organization, when they are going out for these kind of fundings and proposals, to be mindful that they not only create IP, but also look after third-party IP that they could potentially infringe when they commercialize their innovation. Because the last thing that a young company wants is to be sued by a larger organization saying you are stepping on our IP. So it's very important for you to not only create your own innovation, protect your own innovation, but also to look out for your own interest in terms of legally safeguarding yourself and doing this due diligence at the back end to ensure that when your product is launched tomorrow, you are not trespassing someone else's intellectual property. Now, when we talk about intellectual property, as most of you may already know, there are different forms of intellectual property, but there is a common thread between all of these intellectual properties. So, of course, there are patents, trademarks, copyrights, industrial designs, trade secrets. All of these are different forms of IP. But the underlying factor that connects all of these intellectual property rights is that these are set of rights that are granted by a government of a specific country. So yes, all of these IP rights are territorial in nature. No single IP right in one particular country will allow you the rights in another country. If you want an IP right in a specific country, you will have to specifically file IP applications in that particular country. One application in one country will not provide you protection in any other country across the world. So they are very, very strictly territorial in nature. They obviously allow a sort of monopoly to the creation, to the creator of innovation. They have to obviously be original work of intellect. It can't be a copy or plagiarized work from somewhere else. You will not be able to get IP rights on that. And of course, it allows you to safeguard your creation and at the same time prevent others and third parties from illegally using your innovation or your creation. And these are the underlying threads that connect all different forms of IP. Now we'll quickly look at different forms of IP and what kind of protection they provide. So the first on the list is trademarks. Now, as all of you would have recognized these signs, but trademarks are basically a form of IP which can cover names, signs, symbols, mark, color, pattern, words, or combination of words, and trademarks are basically used to distinguish an organization or goods or services from their competition. So when you have a trademark, let's say you have a Nike trademark, you understand that this is a separate entity from Adidas because Adidas has a different logo. Even if Nike as such the name or Adidas as such the name is not written, you are able to make out the difference between the two companies because of their trademarked logo. Now, generally, trademarks are not linked to quality, but there is a perception of a brand. So you know that when you buy a footwear from Nike or when you buy an automobile from Mercedes, regardless of how good or bad they actually are, the perception is that they are likely to be good because these trademarks, these companies have been around for a very long time. They have served the industry, and the general perception and reputation of these companies and their products is very high. So therefore, although they don't directly correlate with the quality, there is a positive perception when brands and trademarks are around for a very, very long time. And yes, so trademarks are perpetual. So they provide protection for as long as you want to have them. You have to, of course, start with the first registration for 10 years, and then you can perpetually renew a trademark. And when you stop using a trademark, you don't have to then thereafter continue renewing the trademark. Now, copyrights is again another form of IP. Copyrights are IPs that are given to literary, artistic work, musical, cinematographic work, musicals, plays, written form of any kind, protocols, and so on. So all of these are examples of copyrightable innovation. Of course, they again have to be original innovation, and copyrights are the term of a copyright as an intellectual property right is the lifetime of the author who creates it plus 50 or 60 years from there, depending on different countries. The third kind of IP that we're talking about are industrial designs. So now industrial designs are basically given to articles for their aesthetic appearance. So here you can see a chair, it is designed in a particular way, doors of a car, the way a fermenter is shaped, the way the Eppendorf tubes are shaped. Now, wherever you have a unique shape, a unique aesthetic appearance of an object, of a material, you can apply for industrial designs. These can be, for example, even your scientific equipments, your medical devices, and so on. So wherever an article has an aesthetic appearance to it, and that is something that has not been done in the past, you can apply for industrial designs. The term of industrial designs is 10 years to begin with, which can be extended by another 5 years. And then the last form of IP that, or penultimate form of IP that we'll talk about is geographical indications, also called as GIs. Now, these are IP rights that are given to a group of people or association of people from a particular geography or location. Now, what these GIs do is to help an a group of organizations or association to be able to produce goods and provide services from a particular location or geography. So when we talk about Tirupati Laddu, now only the laddus that are made in Tirupati can be called as Tirupati Laddus. Now, even if you know the composition, you come and make these laddus here in Bangalore, you cannot call them Tirupati Laddus because you don't have a GI on it. Similarly, when we talk about Kanjivaram saris or we talk about champagne, which is a specific kind of alcohol grown in a specific region of France, only then can you call it champagne. If you make it anywhere outside, you will not be able to call it as a champagne. Similarly with Darjeeling tea or basmati rice. And there's no one individual or one company that owns these GIs. It's a group of companies or an association or group of individuals that belong to that particular region that create these products and services. So this is again another important type of intellectual property right. And then lastly, of course, we have trade secrets. And as the name suggests, these are secrets that are kept within an organization and not let out in public. So these could be your process steps or conditions and parameters or specific ingredients or concentrations or specific protocols, specific know-how or knowledge of how to get to a product or get to a process, any of that. Now, the important thing to keep in mind with respect to trade secrets is that this has to be strictly within the company. And the moment it comes out, you will not be able to, take legal action because you never intended it to be protected by any external IP rights such as patents or trademarks or copyrights and so on. So trade secrets have to be very, kept very dearly within a confined group of people within a company, and special regard has to be taken or special care has to be taken, especially when there is movement of people from one organization to another, because these trade secrets can be carried along and passed on to a competitor. Coca-Cola is a very well known and very well kept trade secret, an example of a trade secret. And then we come to patents. These are for inventions, technological innovations. These could be products or processes or uses, applications of these products and processes. Of course, as some of you may know, Indian patent laws do not allow uses and applications, but there are a lot of countries otherwise who do allow, patents on new use or new applications of a known product or processes. Now, the criteria that are required for invention to qualify as a patent or to be registered as a patent finally is that they have to be new. No one else should have done something similar in the past. They have to be inventive, which means it shouldn't be obvious to someone who is in that field or in that domain. And of course, there has to be some level of industrial applicability associated with that particular innovation. Now, as I said, all kinds of IP rights are territorial in nature, and so are patents as well. They give you a protection for 20 years, and in return, what the patent offices across the world demand is that you provide enough information in your patent application for someone to be able to read it and carry it out. Because once your 20-year term expires, your patents and your innovation goes into public domain, and if any third party wants to then replicate that innovation, they are free to do it after you have had the monopoly of 20 years. So therefore, patent documents have to be well written, have to be technically and legally correct, so that tomorrow no one is able to challenge that, by reading this document, I'm not able to come up with your innovation. That should not be the case. Now, we talked about these different forms of IP. I'm just stopping here to just see if there are any questions in the chat box.
Yeah. There are a couple of questions, but I feel that you can take this towards end. But if you want to take one on trade secret, we can do that because it is immediately connected to this. Can we claim trade secrets while applying? I hope when they means applying, that is applying for trade secrets or something.
So trade secrecy in India, for example, we currently do not have a legislation on trade secret. So there is no way that you can apply for trade secrets. As I said, if it is a trade secret for your organization, for your company, you just have to make sure that it is confined within a very select group of people who hold that trade secret. There is no, there is no institute or organization that you can go to and file for trade secrets or apply for trade secrets, unfortunately. Although the government is working on a trade secret legislation, to define what constitutes a trade secret, where you can get protection for. If there is a violation, what are the things that you need to keep in mind? What are the things that you can do? What are the courts that you can approach? So all of that is in the works, in the pipeline. Government is actively working on it, and we as an IP community believe that probably in next 6 months to 1 year's time, we should have some sort of trade secret related legislation up in the parliament for discussion. But as of now, you cannot apply for trade secrets. You just have to keep them within your company to call them trade secrets.
Yeah, that's why they're secrets. I think we can take a couple of questions here because
Okay,
they just came in.
sure.
Can can I file can I file the patent even if I publish journal my own research work? I think we just discussed this morning this thing.
Yes, so this is, so I will just allow me a couple of slides and I will get to this explicit questions. I'll answer that when we get to that slide.
Okay. I think before we move forward, I think if you could just answer one more, is it compulsory to have patents whole applying for grants? Can it lead to a rejection? I'm unable to understand exact context of this. But
So I think the idea, I think this person is Kavita is asking that if you don't have patents, if you don't have IP, and if you don't fill out anything in those grant proposals, can it lead to rejection of grant proposals? I think that's what they're trying to ask.
hopefully. So would you like to
Yeah.
answer? I would also
Yeah.
like to
So
contribute something towards that.
yeah. So Kavita, I think there is no, to my mind, I don't think there is a yes or a no answer to this question. Different proposals have different criterias in mind and different constraints in mind. Depending on what kind of applications they get in a particular year, what kind of funding they have available with them, and what kind of entrepreneurs come to them. To be honest, if there are, 2-3 different startups vying for the same spot and funding, and if one of them has some sort of IP background and has some sort of, let's say, patent protection for their innovation and the others don't, I would like to imagine that there would be some level of advantage that this particular company would have. But then it would also be important for the other companies who don't have IP rights or patents to be able to convince as to why they don't need patents, or why they have not gone for patents, or why they don't have an original innovation, for example. So I think it is a bit situational, but definitely a company who's had a patent, or especially even if not filed, if it is granted, then even better. But they would have some sort of an advantage, is what I would imagine. Pranita?
Right. Yeah, I just to contribute something here, Durgesh, is that sometimes committee members or panelists, they tend to ask the question about IP a lot. What kind of a IP, whether you have any visibility, if this particular grant, with this particular grant, can you generate some work which can generate further IP? The emphasis on IP is because it can give you a entry barrier in the market going forward, which would help you to commercialize, because there could be a big market players already in the play in some or other way. They would be in your competitive landscape slide as well. However, how you are going to be differentiated by them, how you are going to be sustainable in the market, is based on what you have as an age in terms of product. And if IP is something which can support your product or technology, it can definitely help you commercialize going forward. If somebody would like to get acquired their startup, let's say some entrepreneurs would like to get their startups acquired, or would like to work with some other players, big players in the market, IP becomes really important. So the application may not get rejected completely, but most of the time selection is also depend on that, because additional the parameter or the criteria for select scoring, I'll say, there is this invention, novelty, IP is one section. Of course they're going to score you on that. So briefly on that, yes, Durgesh, over to you.
Yeah, absolutely. I totally agree with you, Pranita. And also, I myself have been part of such committees, or competitions where different startups are vying for the same position. And obviously, when we are judging, or when we are discussing with these startups, the IP element does become important in today's context. Whether you have something or not, and whether you're able to create that monopoly, that niche, that space for yourself in the market or not, depends a lot on IP. So it definitely gives you a great advantage as an organization.
I think, Durgesh, we can move forward. We can take rest of the question later.
Sure, sure. Okay, so now that we have kind of gone through different forms of IP, we also need to understand that each company has its own journey, and each company has its own strategy on how they want to look at IP. Like I said, uh, it's not it's not a given that if you as a company have IP, you're going to be more successful than a company that doesn't have IP. But the chances of that happening is higher. But even when you as a company don't have IP, for example, you should be confident on why you don't have an IP, why you don't need an IP, or you may just be working with generic products and services, and might want to differentiate yourselves on the basis of, let's say, finances or economics or costing at which you offer your products, rather than innovating on a new product or process yourself. So an IP strategy is business driven. And at the end of the day, you as an entrepreneur, you as a company has to decide as to what's best for you in sync with your business proposition. Now, for example, right. So, for example, when we talk about different industries and different organizations within one industry, or different organizations from different industry, um, your technology would obviously vary, and the longevity or the shelf life of those technologies also vary. So, for example, if you are an organization in high-tech space or in telecommunications or software, where products become obsolete very quickly, you have a new television coming out every few months, you have a new mobile phone coming out every few months, so the shelf life is very, very short. Whereas in biotech and life sciences and pharma industry, you take years and years of research to get to that stage of you being able to commercialize your product. But then once you commercialize, it's there to stay. It's not going to be surpassed within a few months or even a couple of years. So depending on the industry and depending on what domain you come from, your strategy as a company for IP would vary. And therefore it would also depend, it would also decide of when you want to file your IP, how broad or narrow you want to go with your IP. Do you want to have a conceptual patent and then build it up as a portfolio, or because your shelf life is very short, you might want to have a very product specific approach and file a patent application only for a specific product, because as a company that within 6 months I will come up with another product. So let me not look at concept as a whole, but try and protect that specific product which is out in the market today and will give me the most benefit. So, and has the maximum chances of being copied or infringed upon by third parties. So again, as a company, whether you're whether you're from X industry or Y industry, what kind of background you have, what kind of problem you're solving in terms of the technology that you are trying to innovate or invent, uh, all of this decides your IP strategy. Also, it's important at the end of the day to keep commercial aspects in mind, because as you would probably have heard, that maybe less than about 2% of all patents that get filed ever get enforced, which means that a lot of companies keep filing IP, keep filing patents, but when it comes to actual commercialization of IP or that product that is covered by that patent, only it happens only in 1 or 2% of the cases. So if you have, let's say, 100 patents filed, the chances of you enforcing is that you would probably enforce only one out of those 100 patents that you would have filed. So it's important for you to not just be blinded by the fact that your company needs an IP strategy, but to make sure that whatever IP you file, patents you file, are commercially viable, strong, and is able to give that kind of protection that you desire. Uh, and that's where we'll also talk about how IP attorneys and firms can help you. But that is where they can help you guide and hold your hand and say that, okay, because your product is from this industry, or because you're looking at this kind of protection, or because these are your competitors, this is how you need to strategize on IP, and not just blinded by filing large numbers, and actually not getting much commercial return from that IP portfolio. So it's important to keep all of those aspects in mind. Also, another thing to keep in mind is what kind of geographies are of interest to you. Of course, as Indian startups, MSMEs, Indian organizations, our first interest would be to protect ourselves in India. But of course, a lot of companies do have partnerships or collaborations at a global level. So you might find that you have innovated a product, and you are actually getting your product manufactured in China or in Southeast Asia and Indonesia and so on. So it's equally important for you to not only have protection in India, but also in China and Indonesia, because tomorrow a third party can, a new company can sprout in Indonesia or China, copy your innovation and start selling in that market. And that will make your product and your company redundant in that market. So important to not only see where you are going to ultimately sell your product, where you will make money, that could be India or other geographies, but also if you have partnerships or collaborations on manufacturing facilities outside of India, keep those countries also at the back of your mind while filing IP. And as we talked about earlier, different forms of innovation require different forms of IP. So let's say if you have a mechanical device or a scientific equipment, what are different forms of IP that you need to look at? You can look at patents, because there is functionality associated with these devices, these equipments. You can also look at industrial designs, because aesthetically, you might have created something which is very different and unique when compared to a similar equipment out in the market. Similarly, let's say if you're working on genes and sequences and antibodies and amino acid sequences and so on, patents is probably the right approach. But then within patents, you need to make sure that your patent covers your sequences, your platforms, your processes, cells, etc. So you have a broader coverage, that tomorrow I am not only able to stop an infringer from copying the sequence, but also a platform on the basis of which I came up with these sequences, or the processes to apply or employ these sequences and so on. So it has to be a holistic protection, not just one sort or one kind of protection. And similarly, let's say if you have a composition, then you of course can go for patents, but you can also look at copyrights, because you may have an instruction manual along with these compositions, or a package insert in your commercial product, and that is copyrightable. So that tomorrow no one is able to copy the manner in which you would have come up with an instruction manual, or some schemes, or some easy way of telling the consumer of how to use it. Someone else is not able to replicate it easily. So you can have copyright protection for that. Another thing to keep in mind for companies is whether you are looking at offensive or defensive IP. You are trying to explicitly enforce your IP, or just stop others. And of course, as an organization, you should try and have a culture of IP, and try and have monthly and quarterly reviews of where you're headed, what kind of innovation you're doing, and whether there is any IP that can come out of these innovations. So as a company, as an entrepreneur, as a startup, as an MSME, you need to decide what is in the best interest of your business and take that direction in terms of IP. But along with that, along with the right kind of strategy that you have in mind for your company, it is also important to understand what others are doing in the same field or in the same geography. Now, you therefore need to have a good assessment of how things could turn out 2 years, 3 years, 5 years down the line, when there are more competitors in this space. So you need to understand the market, what kind of market you're entering to. Is it a young market? Is it a mature market? There are already lots of products in similar space, so you have a lot more competition. Will your product sell? Will it have the right kind of revenue? Or it's a niche market, there are no other products that compete with your product, you're free to innovate, there are chances of greater returns there. Not only focus on bigger markets like US and Europe, but also look at markets like Africa and South America and Middle East, where again, you may have a lot of consumers, but may not have as much competition. So all of those strategies need to be checked and evaluated before you launch a product or go for IP protection in those countries. Also, what kind of players, existing players and companies exist there? What is their IP? Are you infringing on any IP? Can there be possibilities of collaborating with those other companies in those countries? And then what are your strengths and competencies as a company? Are you a company who's small, who just does R&D, basic level R&D, but needs a lot of partnerships across the world? Or you have the financial capability, manufacturing background, uh, enough number of manpower and personnel to be able to go all out and do everything yourself. So you have to assess the strength and competencies of your company to be able to be a successful be able to sell or commercialize a successful product in these different countries. Now, to help you assess all of this, there are different searches and tools that are available, and we'll quickly talk about some of these searches that come in handy from IP perspective. So the first search that we talk about is the landscape. So landscape is basically a kind of search that you undertake to understand emerging technologies and developments in your domain. Now, these could be in markets of interest, this could be at a global level or in a specific geography, and you're basically trying to understand what all is happening in that domain. So you're not very specific in your thought process at this point in time when you're doing a landscape search, and you just want to explore what all is happening, who are my competitors, who's doing what, uh, am I trying to replicate something that already exists, or am I trying to identify a problem that has not yet been addressed in that market? All of that can be determined from a landscape search. So it's a very broad based search. You're not very focused as a company at that point in time. You're trying to explore and you're trying to understand what are the markets, what are the avenues that are open, and I as a business should look at. Generally, this is done at the time of entering a new field of technology, or when an existing company is taking a diversion into a new field, uh, and it provides you a broad view of patent protection and IP landscape in those countries. What is generally considered when you're looking at a landscaping search? You look at patent documents, scientific publications, articles, business news, press releases, pretty much any information that is available on the technology in that particular country. The next kind of tool that is available to you is patentability search. When do you do this? Patentability searches you obviously do when you are close to filing a patent, or you've just filed a patent application, the first application, and you want to assess whether you will ultimately get a grant of your patent or not. You evaluate the chances of obtaining a patent for your innovation, and here any disclosure, and we'll talk about what is novelty and inventive step in a minute, but any kind of disclosure worldwide can harm your patent. So you have to be careful at a global level. Patentability searches are done at a global level. So anyone doing any kind of similar work in any part of the world is going to hurt your chances of getting a patent in any country. And then the last type of search is freedom to operate search, which is basically not looking out for your IP, but you're looking out for a third party IP that you could potentially infringe if you were to launch your product. So these are searches that you try and do to avoid infringing on someone else's patent and being sued by that third party. So this is very, very important, because this is generally done at a stage when you're close to a commercial launch, or you have a good idea that this is how my product is going to be, this is how it will turn out, these are the markets that I am likely to commercialize these products in. And then I carry out an FTO search to understand that are there other players who own IP that my product is infringing, and then is there a chance of me getting legally sued by these companies. So very important to carry out FTO search. Even if you don't do landscape and patentability search, FTO must be done if a company is close to launching a product in any particular geography. And these are geography specific searches. So if you are launching it in different countries, you must ensure that you carry out a freedom to operate FTO analysis and search in those specific countries. So while it's important to look at what others are doing, in parallel, it's also important for you to create your own IP. And as we talked about a little earlier, from patents perspective, what is important is to understand that your innovation is novel, inventive, and is industrially applicable. Now, generally, most innovations you will find that they are industrially applicable, and therefore that is not such a big criteria. Novelty, inventive step are two important criteria that you have to consider when you are coming up with your own innovation or IP. And one of the questions that we talked about earlier is what kind of disclosure can kill novelty and can harm patent. So always remember that your own publication of any kind can become prior art for your own patent application. So let's say, I am a scientist. I generally have an inclination towards scientific journals and publications. I go out and publish that article, and it's all over the internet. And then tomorrow I want to file a patent application. This publication of mine can become a relevant prior art for my own work and stop me from getting a patent. So always, always, always remember, make sure that if it is an innovation that is worthy of a patent, file a patent application first and then publish. Never do it the other way around. Please make sure that is the case. It's very important because it can really come back and hurt you and actually prevent you from getting a patent altogether. So make sure that your innovation continues to be novel in view of your own work, as well as in view of any other work published anywhere in the world. It could be previous applications on patents, it could be presentations, thesis, talks, webinars, seminars, anything that is, searchable and available online or in hard copies. Any of that can constitute a prior art. And if your innovation is sitting, or an innovation which is similar to your innovation is sitting there, you will be prevented from getting a patent because your innovation will not be new at that point in time. It is identical to something which is already existing. The second criteria for patentability is inventive step. What this means is that, okay, even if your innovation is new, was it obvious at any point in time? So let's say if there is if you're looking at ABCD as a composition of 4 different ingredients, and document 1 talks about ABC in a particular field, and document 2 talks about ingredient D in the same field, I as a scientist, can I think that, okay, I will combine document 1 and document 2 and ABCD come together, and my innovation is ABCD. So the patent examiners worldwide would say that, look, coming up with A, B, C, and D together was obvious in view of these 2 prior arts. That is what is called as an innovation being obvious to a person in that field of technology. So you have to make sure that your innovation is new, never has something been done like that before, and also that it is not obvious to arrive at that innovation. Now, in the interest of time, I will not go into the details of course, these slides may be available for circulation later, but I will not go into the details of novelty and inventiveness of how you can defend it. But please remember that for novelty, you need to identify a key differentiating feature. And for inventive step or non-obviousness, extrapolate that differentiating feature and talk about the technical advantages or improvement that key differentiating feature is bringing onto your innovation. So if you combine the two as to why something is new and why something is advantageous with respect to what is already available in that field of technology, you should be able to overcome novelty and inventive step related objections at the prosecution stage of an patent application. Now, I've given a couple of examples. I'll quickly take you through this. So for example, there is a group who is innovating on, coming up with a composition or process of making a new polymeric material. Now, let's say this group 1, the first group has combined natural rubber and polymer 1. They have mixed it slowly under specific temperature and pressure conditions and have arrived at a new composite having higher strength and heat resistance. This is their innovation. Now, what group 2 does is that they follow the exact same components and process steps, which means that their work is neither novel because it's identical to what has been done previously, and there is no innovation, and therefore it can't have any technical advantage because it is identical to what was done by group 1. So it's neither novel nor inventive. Now let's say there is a third group that takes the learning from group 1, and instead of natural rubber, they replace it with synthetic rubber and come up with a composite which has similar properties to the composite of group 1. So while this will be considered as novel, new, because you have not used the exact same ingredients of natural rubber and polymer 1, you have replaced natural rubber with synthetic rubber, so it's new. You are no longer using natural rubber. But it was obvious because I, as a scientist in this field of technology, would know that if I replace natural rubber with synthetic rubber, I'm likely to get similar composite. So it's not inventive, but it is obvious. So I will not get a patent on this innovation. Now, let's say there is a fourth group that takes learning from all these different groups and comes up with synthetic rubber like group 3. But instead of using polymer 1 like group 1, they have used a different combination of 3 different polymers. Now, when they combine synthetic rubber and these 3 different polymers, they observe that the composite that they have arrived at is even better than group 1. So you have novelty because no other group has tried synthetic rubber and 3 different polymers. So you're new, you're distinct, you're different. And B, because it has showed improvement in properties, you also have an inventiveness associated with your innovation. So it was not obvious for anyone to think about merging 3 different polymers with synthetic rubber and arriving at a better composite, and therefore your innovation is inventive. Not only novel, but also inventive. And then you have, let's say, a fifth group coming up, which said, no, I will not do anything that these guys are doing. I will take a completely different route. I will not use rubber at all. I am going to use a completely different component, which was never known to be used as an ingredient in a composite making. And if then I'm able to show some kind of advantage, I'm able to come up with a high strength heat resistant material, then again, because it is different, I have novelty, and it is also inventive because I'm able to show technical advancement. So these are examples that you can keep in mind. And when you're assessing prior art, when you're assessing work done by other groups around the world, this is how you can assess as to whether your innovation is new, distinct, and then also whether it is obvious, whether it was obvious to try, whether the results that you achieved was expected or surprising, unexpected results. Apart from novelty inventive step, there are also different countries have different laws on patent eligible subject matter. In India, we have about 15, 16 different provisions of what is not patentable in India. These are listed down here. For example, any new discoveries, new uses, a method of agriculture, any part or any part of plants, animals, or plants, animals as such. All of these are not patent eligible in India, and you have to be mindful that your innovation doesn't fall in any of these categories. Of course, in US and Europe, you have slightly different situations. Some of these you can get a patent on, but not from Indian context. So when you're looking at an IP strategy, do consider that your innovation is novel, inventive, but also to consider that whether it is falling within patent ineligible subject matter or whether it is patent eligible in India or in other countries. So this is just a quick summary of, I know I'm reaching 5 o'clock, so I'll just finish in the next 5 minutes here. This is overview of patent process for some of you who may not exactly know the process of how this is done. You start with a prior art search. You then file a patent application at a patent office. This could be in India or this could be anywhere else in the world. The patent offices carry out examination and come back. And during this examination, they do exact same thing that we were talking about, the prior art search. They locate closest prior art documents to your innovation and come back and say, hey, your innovation is novel, is not novel, is inventive, not inventive, and so on. That phase of examination is called prosecution. And then once you try and overcome those objections, you basically go back to examiner and say that, look, my invention is novel, my invention is advantageous, there are technical improvements, and these are the reasons. You provide all of that as a written response to patent offices. If they're convinced, they then allow your patent application to go through, and then you have a monopoly for rest of the term, which is a total of 20 years. And of course, if you are interested in maintaining that 20-year term, you have to pay maintenance fee on annual basis. I will skip this slide. Couple of things to consider for startups and MSMEs when you're looking at Some of this we have already talked about, but just to summarize, when you're looking at IP protection, most importantly, look at whether your IP, whether your innovation is commercially feasible, commercially viable. Would you be able to commercialize this technology tomorrow in any form or shape? Whether you'll be able to manufacture a product, sell it, whether you'll be able to license the technology, whether this will act as an asset for your company for a takeover or a merger or an acquisition by a bigger company, in any form or shape. Have the commercial relevance at the back of your mind when you're looking at IP and innovation in your organization. Keep in mind the patenting criteria that we talked about: novelty, inventive step, and patent eligibility criteria. What kind of IP you should look at? Think about that, whether it is just patents or it's a combination of patents and designs, combination of patents and trade secrets, and so on. What kind of application you want to file, what stage of innovation you are at. All of that plays a role, whether you file an initial provisional application, you file a complete application, how much time you need, are you at POC stage, do you have enough examples, enough data, information to support your innovation. All of that plays a role on when and how you file, what you file. Importantly, when you go outside India, when you try and file abroad, keep in mind that the budgetary constraints will kick in. You will have to invest a lot of money. You will have to bear those expenses, whether you will do it, whether your commercial partner will do it, whether your licensee will do it. Make sure that you have a strategy in mind, and try and rely on Indian counterpart in terms of your IP attorney to do the global work, because obviously, as you would imagine, IP attorneys in countries like US, Europe, China, Japan, they are very, very expensive for startups and MSMEs and entrepreneurs from India. So rely on a local good Indian IP firm or agent to do the groundwork, heavy lifting work, and rely on these foreign counsels, foreign IP attorneys to only do the filing bit, only do the procedural part, not the intellectually heavy part, which is done by our local Indian attorney, because there will be a huge cost arbitrage between the two. And then also strategize on what kind of IP you want, whether you want a conceptual IP or whether you want a product specific IP that we talked about earlier, and whether you can improvise on it 2 years, 3 years, 5 years down the line, whether you can make additions to it, improve the innovation. Can there be different uses of a product that you would have manufactured 5 years back? You try and find out a different application, different domain for you to use that product now. All of that would constitute valid IPs. Think from that perspective as an entrepreneur and build on your IP portfolios. And of course, trade secrets. Keep in mind that you have an option of keeping trade secrets. So wherever you don't want to disclose something by way of patent applications, keep them with you. And as I talked about IP attorneys and firms and where they can help you throughout the process, right from strategy building to searches to drafting, filing, guiding you through the prosecution. As I said, rely heavily on your Indian attorneys to do the heavy lifting for foreign applications. And of course, they will also help you to prosecute the application at the examination stage, and then also maintain IP for a period of 20 years. And then at the time of commercialization, if you need their help for licensing or technology transfer, they will then help on the agreements and contracts as well. So this is how IP attorneys and firms can help you. So that's it from my side. I think we have about 25-30 minutes to take some questions, and I'll be happy to do so. Yeah. What do you pray?
I think, thanks, Durgesh. There are many questions which were in the Q&A, some which I tried, answering those questions. Some I think which you should answer. I will ask you. Just before that, couple of questions which we received through registration. They seemed really interesting in terms of proposal writing. For example, one question was, how much information can be revealed in the grant application while the IP is under progress. Let's assume that they have not filed provisional and they are going to file complete specification. Then how much information can be revealed in such grant application?
Okay, so there could be two ways to look at it. One is, like you were saying, if you have not yet filed any patent application, not even a provisional, then the first recommendation would be to quickly file a provisional application, to get a date from which your protection starts. And these provisional applications can be as short as a 2-pager document to as elaborate as a 50-pager document. Totally depends on what information you have at that point in time. Reach out to your IP attorney. They will be able to kind of draft and create a document which broadly captures your innovation, and it could be just as short as 2, 3, 4, 5-pager document. File that, and because everything is online, you will get a filing application number. You will get an application date on the same day that you file. If you file today, you will get a date of today. And then after today, you can disclose any information at any conference, any level, grant proposal, anywhere without any fear. So first things first, do file a provisional application if you have not done that. Without that, there would be some level of risk involved if you were to disclose important aspects of your innovation in a grant proposal. We understand that these grant proposals may or may not be made public depending on the schemes, but you would not want to take that risk. You would want to protect in some form or shape your innovation before you write your grant proposals. And once you have filed a provisional application, then you're writing your grant proposals, you can provide as much information as there is in that provisional application. Try not to overdo the information in grant proposals beyond what is given in provisional, because from provisional to complete, you get 12 months. You will have to supplement that provisional application with more information. But if that information is already sitting in your grant proposal, that in turn can also become prior art for this new piece of information. So we generally suggest restrict yourself to the information that is provided in the provisional application. Keep it as elaborate as possible in provisional, and use the same information in your grant proposal, and to discuss with any outsider during presentations, meetings, proposals, and so on freely, but don't go beyond it.
Thanks. Thanks, Durgesh, for highlighting that such an important point. Because most of the time people file provisional, whoever is aware about that, and then they disclose much more in their grant application. Sometimes I just would like to make a point here. Sometimes that revealing so much information is also not required, because most of the time panelists or reviewers also doesn't want you to give everything, all the information there. They just would like to have some information which will help them to make a decision whether this could be a potential project or not. However, when you are having a face-to-face presentation, and if there are certain questions where you are not comfortable answering that, you may also say that this kind of information is confidential for the startup or the project, and there also you can protect the information, because nobody would like you to share unnecessary information which could put you in trouble. You have already highlighted the importance of provisional patent. That was one of the question in the registration. But one more question before we move to the Q&A chat box. What is the right time to file an IP during testing of product, ideation, prototype, readiness stage? And this is a very frequently, we face this question really frequently. So over to you, Durgesh.
Right. Right. So I think, again, it would depend from project to project and company to company, but we generally suggest that, generally when you are at an early stage of an ideation, or you just have an idea in your mind, at that point in time, try not to file an IP, just keep it to yourself and try and build on that idea. When you reach a stage where you have, let's say, a prototype or a fair idea that all the information that I need to complete this project would be available in about 12 months time, that is the time when you can start thinking about the first filing. So as you were talking about, provisional applications, and then you get 12 months and you can then file a complete application. A lot of times we have seen that companies file the first application way too early in their projects, and they don't have then sufficient information or data to then complete it 12 months down the line. And then they struggle to complete that application. And a lot of times they have to just let go of that first date on which they would have filed. So our recommendation is not to do it too early and not to delay it too much as well. Plan your innovation or plan your experimentation internally in such a way that when you file a provisional, all your information, data, support that you would require to show enablement of that innovation is ready in 12 months time. If you believe that it's going to take 2 years for you to complete experiments and complete the data, then we would suggest delay IP filing, but still continue to hold your information very dearly to only with select group of people, so it doesn't go out. Don't talk about it in public, don't publish it, don't put it out on your website, keep it with you, but work towards a time frame where you are able to generate enough data in about 8, 10, 12 months time, and then you file your first application, generate that data, and in 12 months time you complete that data.
Right. Yeah, this is a right piece of information that everybody should note it, because such grant application where you have a possibility of sharing information at different panels or panel members, you want to protect it with provisional, then you should have a timeline where you would be able to complete, or would you be able to filing following that provisional in 1 year. Okay, so Durgesh, moving on to the next
Just
question is.
just
Okay.
one additional thought. So I think somewhere I also read that someone asked that whether we can file an IP only on an idea, and just on that point, see, your IP is not granted, or your patents are not granted on an idea. It is granted on workability of that idea. So once you have an idea in your mind, it's good. You can think about IP, but don't go ahead directly with filing of IP. See if you can practically make the idea work, and will it be successful in solving an industry or a user problem, end user problem, and whether it'll be commercially feasible, viable idea. If you just have an idea that okay, I can do this, but if in practical scenario it is very difficult to achieve that, then your IP is not going to help you. You will never be able to achieve or get that information that will be required in your final patent application. So don't go ahead and file an IP just on the basis of an idea. Make sure you have a concrete plan around that idea, that this is how I will do the experiments. I have already done some of it. I have a fair level of confidence that this idea will work. Here is some level of data, but I need another 6, 8, 10 months to complete that data, and then I can file a complete. So only when you have at least that threshold of confidence that this idea will work and I can show its workability is when you should go for an IP.
Got it. Thanks. There's another question on the trademark, whether trademark can be combination of words and design.
Yes. So for example, I can think of Pepsi, for example. So when you have the logo of Pepsi, the blue and red, the colors there, you also have Pepsi written in between. So Pepsi, for example, has trademark protected its sign with just the blue and red colors, as well as blue and red colors along with the word Pepsi written in between. So both act as trademarks for Pepsi, and they can use it as and when they like. So you can have a combination of different things. One thing I had forgotten to mention, that even sounds can be trademarked. So for example, older times when we used to turn on our Microsoft laptops or even desktops, there used to be this Intel sound that used to come, and even that sound, for example, is trademarked by Intel. That typical sound that used to come when you used to switch on your desktops, and sometimes even now that happens. So that the sounds are also trademarkable IP.
No, I was not aware, so thanks for that information.
Yeah.
So another question followed to that from the same participant: how to search whether our trademark is unique or not?
Yes, so there is most forms of IP get published by these government agencies, government offices. Patent applications, for example, get published almost immediately after 18 months of their tenure. Similarly, trademarks also get published, and every Friday, if I'm not wrong, there is a trademark journal that is published by the Trademark Registry of the Government of India, and you can search through them. And that's where you will be able to figure out whether a competitor's trademark is similar to yours, or your trademark is similar to someone else's, and so on. So it is searchable. There are also databases available that different IP firms and IP teams use to do these searches. Because unless you are absolutely confident that your trademark has never been used before, you should be confident of that before applying for trademark.
Okay. which IP category will a product belong if it has hardware plus software modules? Will the IoT hardware be part of the industrial design? And can we patent software process like a mobile app?
Yes, so there are different components to this. So first things first, software by itself is not patent eligible in India and US and a lot of other countries. What you need to do is connect this software with the hardware in your patent application. So you say that this is the software, this is the technical effect that it produces on a specific hardware. So even when you have claims or patent applications being written for software, they have to be combined with the hardware. So you will not have a claim on software alone. It has to be software plus hardware in combination. So that's first. Second is that patents are the most important form of protecting your functionality or technical aspect of your software. But the software code as such can also be copyrightable. So you can copyright protect your code as such, but in your patent applications, you do not give the code. You just need to give the functionality of the code, of how it works and what is the technical effect that it produces. So let's say you write a code to shrink the size of a document online. So you don't have to give the code. The code can be copyrightable, but you have to show how the technical effect is brought about by your software, that if you do XYZ steps, you are able to reduce the size of the file from XMB to YMB, and that is the technical effect that you will get monopoly on. So anyone else coming up with a different code also, but getting the same end technical effect, will be infringing on your IP right. So that from that perspective, for software, patents become more important because codes obviously can be changed, but the technical functionality is what you will get protection on. So from that perspective, software patents become important. And then the last thing on mobile apps, so you do have a design registration, which is called as GUI, graphical user interface. GUIs are gray area in some countries. Recently, in the last 1 year, we have had some orders from courts that have allowed registration of GUIs, which means that on a mobile app, how does the particular app work? How does it look? What kind of icon it has? When you click on that icon, what happens inside the screen? All of that is registrable under design protection in India. So GUIs, as they are called, graphical user interface, are mobile apps that can be registered. Pranita, you're on mute, I think.
Sorry. Yeah. How a company can maximize the potential of its commercialized patent, which is going off patent in coming years. He's talking about probably the patent who is going to expire soon or complete 20 years. How to maximize potential of its commercialization. It could be very subjective, but if you would like to answer that.
Yeah, so I mean, a lot of larger organizations or companies, even smaller ones that are aware of IP, they would have already started planning for this. And generally, what they do is they try to build on their product or process that they would have. They would try to do improvements on it. They would try to, so let's say, for example, it's a composition and you have specific concentrations. Can you then try and come up with another composition which probably achieves the same function, but maybe components vary a little bit, concentrations vary a little bit? Can you show that there is an additional advantage with this new product? So you basically try and build on that original patent that you would have that is about to expire. You try and do incremental innovation on top of it so that you are able to build a portfolio outside of that one patent, because once that patent expires, you will not have any monopoly in the market, so as to say. So you try and build further on that portfolio, on that product, and start early, because this R&D and this kind of patent protection sometimes is tricky to obtain, because a lot of patent examiners around the world also understand that you are reaching your 20-year term. You would want to probably do just a little bit tweaking here and there and try to come up with a different patent. Try and do genuine innovation on top of your original patent. There are ways and means of protecting these innovations. You can file a regular patent application. You can also file something called as a patent of addition. There are continuation applications that can be filed in US, for example, and all of these have different criteria. But to sum it up, it's important that you try and do some level of innovation on top of this to be able to get a separate protection for your patent that is expiring.
Okay, Durgesh, I'm going to unmute Sandeep here, who has raised his hand. Sandeep, please go ahead and ask your question.
Thank you very much, Dr. Pranita and Durgesh. First of all, I have sent my, LinkedIn invitation to both of you. If you could accept it, I'll be highly grateful. That is one. Second thing is we already have provisional patent, and now there is a patent attorney. Durgesh, you are in Bangalore. Bindu Sharma is our patent attorney origin. So,
Right.
and I understand she's also pretty well known in the industry. And we are very fortunate that she is part of our leadership team in terms of the patent. My question is, in case we have taken patent and under PCT, we have applied for 150 countries, but we are India-centric as of now, at least in near short term. But PCT under 150 countries, once we go live in India, which will happen in another less than 60 days, and imagine Singapore, where we also have presence, we delay going to Singapore and say after 2 years we want to go. How will we must protect our turf in those markets where we have not gone live?
Okay, so Sandeep, I believe that have you already filed a PCT application?
Yes, we have filed
Okay.
a PCT application and we have been given that some number also.
Yes, correct.
I have paid $100.
Now,
$100 is the fee.
Yes. So once you file PCT application, Sandeep, depending on when you have filed the PCT application, so generally you get 31 months from your first 30 or 31 months from your first filing date to go live with your application in any of these 153 countries. So for example, you took Singapore as an example. Now let's say you can see that Singapore will become an important market for you, but right now it may not be. So you can take advantage of this delayed term that PCT provides. You can take this additional time of about 18-20 months and then file an application in Singapore, which will then allow you protection in Singapore at a national phase stage. Now that same process you can follow in any of the 153 countries within the PCT. So you don't have to, so a big advantage of the PCT process is that you don't have to take that call immediately. It does allow you that additional term of 18 months beyond the first 12 months. So you would have filed provisional, then you would have completed it, you get 12 months. Within that 12 months, you have to file complete and PCT, and from there you get another 18 months. So total period of 30 months, but from PCT you get additional around 18 months for you to take that decision that out of these 150 odd countries, which are the countries that are of interest, and there you can then file those national phase applications.
Okay, thank you very much. I really appreciate that. If you can give your WhatsApp also, I'll offline ask other question. I want others to also get a chance.
Yeah,
Thank you.
thanks Sandeep for joining. We'll definitely pass on their email address to you so that you can get connected and then you can have a discussion on this. So quickly, two more. I think we will be able to accommodate only 2-3 questions now. If you could be quickly answering those. See, certain products or process may be additive to the primary application, but are identified post-provisional. I mean, here primary is provisional, but are identified post-provisional application. What course of action should be taken in such cases?
Yeah, so generally we recommend that your provisional is as broad as possible, and this is where maybe your IP attorneys can help you try and keep them as broad as possible and envisage few other things that you may not have right now but are possible in next 6 to 8 months time. That's number one. Number two is that even after those precautions, let's say 2 months, 3 months, 6 months down the line, you come up with something totally different, but in some form or shape related to your first invention, then you can file supplemental provisional applications at any point in time in that 12-month. And then when you reach the 12-month period from the first date, you can combine all of these provisionals and file one complete application. So what I mean to say is you file first provisional, then let's say after 3 months, you file the second provisional, after 3 months, you file another provisional. You combine these 3 provisionals at the end stage, and then file one single complete application, provided that these three different innovations that you're filing in your provisionals are related, can be combined, and they were not originally captured in your first application. So you can do multiple provisionals and then combine them at the end. A lot of companies do that when they, let's say, have not been able to envisage enough stuff in their first application, but after 2 months they realize, oh, I forgot or I missed out on something. They file a supplemental provisional and then they combine the two and then file a direct complete at the 12-month stage.
Yeah. I think there was one question, how FTO analyses are performed. If you want to briefly would like to tell you about the process that you are in.
Okay, so FTO, as we said, is number one, geography specific. Number two is looking for patent applications or granted patents. It is not looking for publication or journals or scientific literature, none of that. It has to be specifically patents, because what you're looking for in FTO is whether you are infringing on someone else's IP rights, and IP rights, you mean patents. So in FTO analysis, you first understand the technology. So let's say you have a technology. I will understand your technology, that, okay, this is the broad contours of your technology. This is what the technology relates to. I then devise a key string, a search string that I will employ in different databases around the world. We and a lot of IP attorneys have access to some sophisticated paid databases that cover patent and patent applications from across the world. Now, if let's say your interest is India or your interest is US or Europe, we then take that geography, we put a filter of that geography, let's say US, and then we put in this key string and come up with all patent applications and granted patents in that country. We then filter. The first stage of filtering is whether they are live or not, or whether they've been abandoned or they have surpassed their 20-year term. If they are alive, we then look at those patents, we go through them, we review them, and wherever we believe that your product is falling within the ambit of their independently worded claims is where we flag that particular document. We then shortlist these documents and then we analyze them more closely. So at the end of the FTO exercise, we may have from 500 documents, 1,000 documents that we started from, we may have 5-7 very, very close documents. We will give our analysis and we will send the reports to you saying that, look, your technology is infringing on these 1 or 2 documents. These are ways and means by which you can customize your technology so that it doesn't infringe, or there are no ways out. You will have to take a license from this third party. So we give that opinion, and that's how an FTO analysis is concluded.
Thanks. I think we can take just one more question. Okay, one question where, in fact, I would also like to contribute. Is it okay to have patent with the institute rather than company, as it would still take some time to establish? What are the rules for licensing in case the patent with the institute is required to be used for commercial use by the company? Also, in what ways can we protect the idea temporarily if not patented yet? If you are okay, Durgesh, I'll just go first.
Please,
and then
please go ahead. Please go ahead. Please go ahead.
Since I would like to share my experience at IIT Bombay, I take that, let's say, institute is IIT Bombay. You can have a joint patent with the institute. However, you'll have to share that IP rights with the institute. If you are already an established startup and if you have done the work, or if you can do the work on your own, let's say if you do not require the infrastructure or any other technical support per se from any institute, then you can have that IP on your own, because that IP remains with the startup. However, if the technical support, infrastructure support, R&D support, without which you may not do particular work and which may lead to the IP, in that case, it could be a good idea to go with the institute. However, you will have to share, or the institute files the IP, because they becomes the primary applicant and other becomes the innovator. However, more details would help, that whether the startup is also part of that, also spun out from that institute, or it is completely outside, from startup. So that information would definitely help in certain other ways to answer this. But at IIT Bombay, what happens is that if any faculty member or any technology spun out from IIT Bombay, let's say student also have the startup, the IP belongs to IIT Bombay, it is shared between them. So in that case, a primary applicant is IIT Bombay. The startup has to license that technology from IIT Bombay. They get a NOC as well as to use that technology to further develop the product. If any IP is based on that parent IP, again, that may have to be sometime how it is based on that primary IP, and then again the further IP sometimes needs to be shared if at all there is a significant overlap. Now all this is because if somebody has to go with the institute, if you can have if startup can work on their own and develop this IP on their own with somebody as an advisor from this institute or something, then it would be good idea to have your own IP, because it will be just startup IP. You need not to share with anyone, because taking license from institute has its own cost. At IIT Bombay, of course, it has. So this is how it may have a impact on the monetization, or maybe taking it as a license in terms of fund requirement and all that. So that's something from my experience over the Durgesh.
No, I think you've covered everything. So yes, we've seen similar models with most IITs, and even we work very closely with IISc, NIPER, and a lot of other institutes. At the end of the day, you have to realize that all the educational institutes or academias are very keen to license out their technology, because at least in India, the technology transfer is not as robust as as in the West. So all institutes would be keen to have partners or collaborators, whether it's the students or whether it's outside companies or startups, to collaborate in some form or shape, which allows them to transfer their technology or license out their technology. So I would say that most institutes of good repute would be happy to collaborate with their own students or with outside startups to take license to license out the technologies. And generally, what I've seen from my experience is that these institutes are not very greedy in terms of what they expect as a return, because they understand that these are startups or these are young students coming from their own labs, and they would obviously be mindful of all of that financial constraint. And so licensing out a technology becomes more important than the rate at which the technology is licensed. So
Yeah.
so you have a good chance of licensing out a technology with an institute. Yeah.
Yeah. And IIT Bombay here has a very friendly policy. I think
Yeah.
you are also aware. So we
Yeah.
have a good IP policy which encourages faculty members, students, in fact, even have a collaborative work with outside startup. I mean, when I say outside, when they have no IITB as such connection of alumni or any, on-roll faculty or anything. So the policies are friendly. So if you want to collaborate with an institute, it's important to look at their IP policies as well before you do that. In case of IIT Bombay, we have seen many examples where people collaborate with faculties, and they successfully develop good IPs and commercialize them. Okay, I think we have crossed 5:30. This thing. There are many questions. If you want to stay back for 5 minutes and take a couple of them.
I'm okay. Yeah, sure.
Okay. Is it okay? Okay, we have taken this institute. There is one question. If we get to know that similar to our product or design is already patented in the US, so design or product is already available in the US, we also can not go back and redesign our product. What would be the best way to handle the situation?
Okay, so first thing is that even if the design and product is available in US, is US a commercial market for you? If US is not a commercial market, and you have to of course see whether that patent exists in India or not. If it doesn't exist, you are free to commercialize in India. But even if US is of interest, and if that company also has a patent in India, then you're basically blocked from commercializing that innovation. Then redesign is the only other thing. Design around is another thing, that you don't have to completely redesign your product, but maybe just tweak it enough to change it vis-a-vis the independent claims of that third party's patent. And again, your IP councils and firms can advise you on what what is the minimum change that you need to do to overcome the independently worded claims from that patent. That is, I think, the first thing that you can do. Otherwise, if there are no possibilities of redesign or designing around the patent, then cross licensing or licensing in the technology is the only way.
Yeah.
But I'm sure your IP attorneys would be able to figure out a way as to how you can tweak your product or process in a way that is able to overcome the patent, because generally patents in today's day and age, when they are filed and granted, they're granted after a lot of scrutiny, and there is significant amount of limitations that come into the claim language. So when we are assessing the infringement, we have to ensure that all of those criteria and limitations are met by your product. And even if one of them is something that can be designed around, then you will be able to successfully overcome or bypass that patent. So before you think about redesigning or completely dropping it or licensing opportunities, approach a good IP attorney and maybe take a second advice and see how you can design around the existing.
Yeah, yeah. Yes, yes. I think there is one question on the similar line. They were asking, we're at a really early stage. How important is the IP attorney for them? Should they hire one? What are the type of service provided by attorney and what are the charges? I think before you answer, I'd like to say, don't think of hiring them. You can just use the services by these IPA. There are IP attorneys, there are firms. Just contact them and try to use whatever different services which are applicable to them. Don't try to hire them. They're, trust me, they're very expensive. And what are the type, at early stage, getting advice from the IP attorneys, involving them with what you are doing is really important. That's how Durgesh mentioned about the prior art search, F2 and all that, that becomes really important. So we will recommend that, and we most of the time we recommend that if there is some funds available, there are a lot of subsidies available from the Maharashtra government as well for IP filing. Nowadays, IP firms provide a lot of discounts, on these different services for the startup. So do contact them. KNS partner is one of them. Do let us know. We can connect you with them. If we at all, before we close this session, we quickly touch upon, because there is one question: how we attract the investors if our company is formed with patented product? It's from Mohit. If you want to just say something.
How can we attract investors if our company is formed with patented product? Of course. So see, if you have, so as I was saying earlier, your company will definitely be at an advantage if you have a patented product. I think the next step, if you already have a patent on your product, the next step would be to try and leverage that patent, by reaching out to different investors, by talking about your IP rights, and the kind of protection you have in India or other geographies, and also, to not just to supplement, not just to talk about your patent, but also supplement it with the fact that you've also done enough due diligence to understand that your patent is strong. There are no third parties that can come after your patent. Also, when you launch a product, you are not infringing on someone else's IP. So that gives investors a lot of confidence that tomorrow, when they try and invest your company, there is no chance or very little chance that your company will get into legal trouble, either through a third party or in any other scenario. So that gives a lot of comfort and advantage to you as a company, that you have not only secured patent, but you have also looked at a couple of these other things, whether you are infringing on someone else's IP and whether someone can bring down your IP or not. One way to do that is to do something called as invalidation search, where you basically try and bring down your own patent. So you let's say you do your own search and you say, okay, what are the closest prior arts that a third party can cite against my patent, and whether I will be able to defend against those third party prior arts or not. If I'm able to successfully defend, then you obviously have a strong patent, because even if someone tries to bring down that patent tomorrow, you will be able to successfully defend. But if those are prior arts that are strong, then you may want to have a backup strategy, maybe have a different innovation, or maybe decide on a different product, or define or try and design around to overcome that prior art, have different strategies as a backup, but it will be good to know whether a third party will still be able to knock off your patent or not. And if you've done that groundwork and due diligence, investors get a lot of confidence that A, you're not infringing on someone else's IP, B, someone else cannot bring down your IP.
Right, right. And just would like to add one more point is that sometime in case if you are getting, let's say in future, if you're getting acquired at particular stage, there are startups who gets acquired all the time, right? So if you are getting acquired, that becomes an asset, which then, parties are like this, they'll sit together and they'll understand, the entire asset of the company that will help you getting acquired or in any other forms of your startup is moving through these phases. So IP becomes a really important part there. So that is why it is really important to protect your intellectual property. There are different types of intellectual property Durgesh has highlighted at initial stages your product development, validation, because while you are also validating your product, you will be disclosing. There was actually one question, Durgesh, in the registration, which I remember that during a regulatory filing, you'll have to write a protocol, you have to give it to someone, you disclose too much information during that process. How important it is, to protect that information. How can we do that? I think in a process you answered that you have a file, you can file provisional, complete specification and all that to protect that. So this is how every startup should have a strategy for their IP planning throughout their entire phase, because it's not going to be just one IP, intellectual property. There would be many forms of intellectual property and many patents, process, utility or design, or sometimes all these you'll have to file at different stages. They need funds. So I request you file your strategy, and for that you have to contact a relevant IP attorneys, firms who can help you to do plan that strategy as well. I think with this, Durgesh, it's around 5:42. So there are questions, but I request all the participants to write those questions to us. We have already highlighted the email addresses here, sine_big@sineIITB.org. And I have also mentioned the Durgesh email address here as well. Do write to us and send your queries to us. We'll try to get it answered from Durgesh to you. And I would like to thank, first of all, Durgesh, for your time, even stretching here after 5:30, the committed time. So thank you so much. And the crisp presentation, because even I learned few things today, and the question answers, itself says that, a lot of participants received a lot of information today. But, if you need more information, do write to us, to talk to us as well. And thank you all participants for joining us for this session today and staying us with us post 5:30 as well. Thank you so much. Thank you for actively participating in question answers as well. Thank you. Thank you all.
Thank you, Pranita. Thank you to your team, and thank you for this opportunity, and thank you to all the attendees to spend so much time and effort to understand and learn about IP. And as Pranita said, we'll be happy to answer any follow-up questions that you may have. Please feel free to reach out to us.
Yeah, thank you. Thanks a lot. Have a great evening. Thank you all.
Thank you, everyone. Bye-bye.
Yeah, bye.